If your immigration case has been sitting frozen for months with no movement, no answer, and no end in sight, this video could change everything for you. Right now, federal judges across the United States are stepping in and saying, enough is enough. USCIS cannot keep you in permanent limbo. Courts are ordering the agency to move. But here's the critical part. Not everyone is covered. You need to know exactly where you stand and what to do right now. Stay with me. This update is extremely important. Welcome back to Immigration Updates today. This week brought some major legal developments that directly affect hundreds of thousands of immigrants across the United States. We are talking about the USCIS adjudicative holds. These are the indefinite freezes placed on immigration applications filed by people born in any of the 39 countries listed under the Trump administration's expanded travel ban. As of April 2026, a sweeping USCIS adjudication pause linked to the travel ban has placed millions of immigrants in legal limbo. Cases ranging from green card applications to work permit renewals to DACA renewals are sitting completely untouched. But courts are now pushing back hard. This video will walk you through what the holds are, what the judges have actually ordered, who gets relief and who does not, and most importantly, what action you need to take right now. Section 1. What are these USCIS holds and how did we get here? Let us start from the beginning so everything makes sense. On December 2, 2025, the Trump administration placed a hold on all asylum applications filed with United States Citizenship and Immigration Services. The administration also began pausing green card and other immigration applications filed by individuals from 19 travel ban countries. Then things escalated quickly. In December, the White House announced a significant expansion of the ban beginning on January 1, 2026. The travel ban list grew to include 39 fully and partially restricted countries, and USCIS moved in lockstep with that expansion. As of January 1, 2026, USCIS placed an adjudicative hold on all pending immigration benefit requests for anyone born in or a citizen of one of the 39 travel ban countries. This includes applications for green cards, employment authorization documents, naturalization, and affirmative asylum. Here's the part that shocks most people. This hold applies regardless of when you entered the United States. Even if you have been living and working legally in the country for years, if you have a pending application and you were born in one of these countries, your case is on hold. That is the core of the problem. People who did everything right. People who waited years. People who paid fees. All frozen. Section 2. The scale of the problem. You need to understand just how large this crisis really is. A recent analysis found there are nearly 12 million applications awaiting a decision from USCIS, with 247,000 that have not even been opened. An immigration attorney estimates that about half of all immigration applications currently at USCIS are impacted by these travel ban-linked pauses. The impact covers everything from spousal sponsorships to work permits to DACA renewals for people from the 39 countries. And the real-world consequences are devastating. For many immigrants, the pause means their work authorization is expiring, their legal status is at risk, and in some cases, they face deportation if their case is not decided in time. DACA recipients from the 39 affected countries face a particularly urgent threat. An expired DACA grant removes both work authorization and deportation protection at the same time. Spousal and family petitions frozen by the pause leave couples separated or unable to obtain travel documents. One man in Texas who came to the United States in 2023 and graduated with an engineering master's degree said he had to turn down multiple job offers because his work permit could not be processed. He said he barely could feed himself and barely could pay his bills. This is not a minor administrative delay. This is people's lives, families, and futures on hold. Section 3, the courts are stepping in. Now, here is the news you came for. Federal judges are saying this policy is unlawful and they are doing something about it. On April 30, 2026, United States District Judge Julia Kobik in Massachusetts granted part of the plaintiff's request for a preliminary injunction. This type of court order can temporarily stop the government from enforcing a policy while a lawsuit continues. The two policies she targeted were the adjudicative hold policy, which paused final decisions on certain immigration applications, and the significant negative factor policy, which allowed officers to treat a person's nationality as a negative factor in immigration decisions. Judge Kobik was direct in her language. She wrote that there is no indication that USCIS meaningfully considered the consequences of throwing thousands of benefit applicants into indefinite limbo and perpetual uncertainty about whether they will be granted asylum, become a United States citizen, receive work authorization, or obtain a green card. She also rejected the government's reasoning, finding the policy to be broadly discriminatory. The Trump administration failed to demonstrate a reasoned basis for concern about public safety or national security risks by individuals from the 39 identified countries living in the United States today. Then on May 7, 2026, the same court went further. A federal judge in Boston issued an order directing USCIS to immediately lift its adjudicative hold for 266 plaintiffs from the 39-country travel ban list. The court also found that USCIS does not have the authority to perpetually decline to adjudicate applications that Congress and agency regulations require it to decide. The court also blocked USCIS from enforcing a policy alert that had directed officers to treat country of origin as a negative discretionary factor in benefit decisions. And this was not just one court acting alone. By late April, at least 9 federal courts had blocked the adjudicative hold for individual or group plaintiffs, with rulings coming in from courts in Arkansas, Maryland, and Massachusetts. A Maryland judge put it simply and powerfully. He ruled in a 39-page decision that USCIS does not have discretion to decide not to adjudicate at all. Section 4. Who gets relief and who does not? Now, this is where you need to pay very close attention, because the court orders do not apply to everyone. The rulings do not lift the hold across the board. Applicants from the 39 countries who are not named plaintiffs in one of these active lawsuits are still subject to the hold. The legal momentum is moving against the policy, but you are not automatically covered just because a judge ruled somewhere. Let me say that again in plain language. If you are not part of one of these lawsuits, the hold on your case may still be fully active. However, the judge's reasoning is powerful and matters for everyone. Since the court found that the plaintiffs are likely to succeed in arguing that USCIS acted unlawfully, this opens a clear pathway for more legal challenges. There are at least 33 lawsuits challenging the pauses right now, filed by individuals as well as on behalf of large groups. This is an active, fast-moving legal landscape, and every week more people are being added to injunctions. Section 5. What is the government saying? You might be wondering what the government is saying about all of this. A USCIS spokesperson has stated that USCIS has paused adjudications for aliens from high-risk countries while working to ensure that all aliens from these countries are vetted and screened to the maximum degree possible. The agency stated that the safety of the American people always comes first. The government has not conceded the merits of the cases and has preserved its arguments for a potential appeal. So this battle is far from over. Even when a court orders USCIS to act, the government may challenge that ruling at a higher level. And even if you get a positive ruling, do not expect your green card or work permit to appear the next day. Processing remains slow even when legally required. But at minimum, these rulings are forcing the government to acknowledge it cannot hold cases indefinitely without legal justification. What you should do right now. If you or someone you know is from one of the 39 affected countries and has a pending USCIS application, here is what you need to do. Do not wait. First, contact an immigration attorney as soon as possible. This is the most important step. An attorney can review your specific case, tell you whether you are already covered by an existing injunction, and advise you on whether filing a mandamus action to force USCIS to act makes sense in your situation. Second, document everything. Keep copies of all receipts, notices, and correspondence from USCIS. Note the exact date you filed your application. If your work permit or legal status is at risk of expiring, flag that urgently to your attorney. Third, do not travel internationally if at all possible. If your application is pending and you leave the United States, re-entry may be extremely complicated or blocked entirely depending on your situation and country of birth. Fourth, respond to every USCIS notice immediately. If you receive a request for evidence or an interview notice, work with an attorney to provide full and complete responses as quickly as possible. Fifth, stay informed. This situation is changing week by week. New court orders are being issued. New plaintiffs are being added. The legal picture in May 2026 looks very different from what it looked like in January. Keep checking trusted immigration sources and channels like this one. Let me quickly summarize the key points from today. The Trump administration placed indefinite holds on USCIS applications for nationals of 39 countries, beginning in late 2025 and early 2026. Those holds affect green cards, work permits, naturalization, and asylum for people already living in the United States. Federal judges in Massachusetts, Maryland, and other courts have ruled that these holds are very likely unlawful. Courts have ordered USCIS to resume processing for specific plaintiffs. As of May 7, 2026, 266 plaintiffs in the Doe v. Trump case in Boston have received direct relief. But if you are not part of an active lawsuit, your case may still be frozen. The momentum is on the side of affected immigrants legally, but you must take action to benefit from it. If this video helped you understand what is happening and what you can do about it, please give it a like right now. It genuinely helps this channel reach more people who need this information. Share this video with anyone you know who is from one of the affected countries and has a pending USCIS case. They may not even know this legal fight is happening. You could make a real difference for them. And if you have not already subscribed to Immigration Updates today, subscribe now and hit the bell. This situation is moving fast. New court orders, new policy changes, new developments. We cover it all so you do not have to search for it yourself. Stay informed, stay prepared. We will see you in the next update.